All right. Good day, everybody. My name is Andrew Holmes. I'm the brand director for Goslings Rum here in Bermuda. Very fortunate to be joining everyone from Bermuda today, my home where I was born and raised. And we've got an exciting topic for you guys here today: navigating the dark and stormy waters of trademark. So it's something that Goslings is very passionate about, and we look forward to sharing a lot of information about that today. Our presenter today, Mr. Daniel Eun. Daniel is an OG in the craft cocktail movement, was the first head bartender at PDT in New York, and then opened Varnish in his home in LA. Then he decided to change things up a little bit, took the wrong bar exam, and has a unique skill set being a bartender and an attorney. He then got back into hospitality as the general manager of the Normandy Club and the Walker Inn, and is currently a managing partner of the West Side Hospitality in Hong Kong, as well as Second Ward Hospitality in Austin, and is also on the board of the Institute of Better Drinking with our mutual friend, Eric Castro, bartender at large. So Daniel and I first had the opportunity to meet in July of 2019 in New Orleans at Tales of the Cocktail, and we're very excited to have Daniel present for us here today. So I'm just going to take this opportunity to give everyone a little bit of background on Goslings, the history of the family, and a little bit about Dark and Stormy before we get into the intellectual property side of our presentation from Daniel. So Goslings is a family business, and it is currently managed by the 7th generation of the family. However, there are now 7 members of the 8th generation working in the business, which is a really good sign. And the family is originally from England. There was a gentleman by the name of William Gosling, who was a wine and spirit merchant in London, England, and wanted to expand his business to the new colonies in America. So in 1806, William Gosling chartered a ship called the Mercury, asked his eldest son, James Gosling, to get on the boat and make the voyage across the Atlantic. So naturally, James was quite excited to be getting on a boat with that much of his father's alcohol. And the world's first booze cruise set sail. And fortunately for us here in Bermuda, they never made it to their final destination of the new colonies. They were becalmed at sea, and the captain gave James an ultimatum. Either they had to turn back and go to England, or push on to the closest British port, which was St. George's, Bermuda. So in August 1806, James arrived on the island with his cargo of wines and spirits. So if you can imagine, back then, it would have been brandy, whiskey, sherry, port wine, and gin. And Bermuda, for those of you that aren't familiar with it, it's a British dependent territory, the oldest dependent territory of the United Kingdom. And it's 21 square miles, inhabited by 60,000 people currently. Therefore, not a lot of agricultural land, and certainly not enough land to grow quantities of sugar cane. So in 1809, the British Navy arrived in Bermuda, and the Goslings recognized demand for rum with the Navy on their doorstep, and began sourcing rums from all over the West Indies, shipping them to Bermuda and experimenting with blending and aging to create their own style of rum. So it was about the mid-1800s, 1850s, when rum started to arrive in Bermuda. So Goslings has been blending and aging since then, and not much has changed. The Black Seal is the flagship rum for the Gosling family, and originally that rum was referred to as Old Rum. It was sold on draft from the barrels that the rum was aging in, and eventually was bottled in once-used champagne bottles, which were recycled from the British Navy officers in the Royal Naval Dockyard. So they would take the bottles, fill them with rum, cork them, and use black wax to seal the cork on the bottle. So that's where the name Black Seal comes from. Bermudians would go in and request the name, or request the rum with the Black Seal. So it was a play on words, and it's now the largest export from the island, and a very significant part of our culture here in Bermuda. The signature drink for the Black Seal rum is the Dark and Stormy. And Dark and Stormy has its origins, again, with the British Navy, who had a ginger beer factory in the Royal Naval Dockyard. And ginger beer was sort of a medicinal tonic back then, used to cure stomach ailments and help with seasickness. It wasn't long after they began producing ginger beer in the dockyard, and they began selling to the locals, who quickly figured out what the ginger beer was missing: Goslings Black Seal rum. And so when the rum is floated on top of the ginger beer, it looks like a storm cloud. So it was given the nickname Dark and Stormy. And Goslings first trademarked the name Dark and Stormy June 9th, 1980. So yesterday, we celebrated 40 years of the trademark anniversary. And it was also in 1980 that Goslings began to export rum from Bermuda. So prior to that, it was only sold on the island and available to those that were lucky enough to get to Bermuda and snatch a bottle on their way home. And there was a lot of yachting races, ocean races that would arrive in Bermuda, and the sailors would load up rum either in barrels or in bottles and take back to the east coast of the US. So Dark and Stormy first export market was the east coast of the US, and it really started to develop a following with the sailing community because of all these ocean races going back full of Dark and Stormy and Goslings rum. And so now it's Goslings is available all over the world. It's still blended here in Bermuda. We also bottle rum on the island for the domestic market. And we have 3 co-pack facilities that we work with internationally to bottle the product for export. But every drop is blended in Bermuda. And it was also in the mid-1980s when we partnered with a company on the island to can a ready-to-drink Dark and Stormy. So we were a little bit of ahead of our times with the RTD, and that was made in Bermuda up until 2010. And in 2011, we established international canning of the Dark and Stormy ready-to-drink, which is now available in North America, Europe, and the UK. So it's our trademark cocktail, our signature drink for Goslings Black Seal, and it's also known as the national drink in Bermuda. And it was one of our former premiers of the island who declared it the national drink. So although we're a British colony and we sing God Save the Queen, we proudly recognize the Dark and Stormy as our national drink here on the island. So I think at this point, I would like to turn you over to Daniel, and we're going to start the presentation on intellectual property.
Cool. Yeah, thanks for the history and and touching on why trademarks are important when it comes to cocktails. Let's start from the beginning. Basically, what is intellectual property? Like, why do we care about it? It primarily refers to creations of the mind, right? It's your inventions, literary, artistic works, symbols, names, images used in commerce. Primarily now we've kind of recognized 4 main kinds of intellectual property. There's patents, which covers inventions. You have trademarks, which are those symbols, names, and images used in commerce. And then you have copyright, which is things of like literary and artistic work. And then you have trade secrets. So moving on, like, why do we care? Why does it need protection? There's a couple policy reasons that really kind of spurred the recognition of intellectual property in the world, and why people cared to protect it. One was kind of the idea that progress and really kind of rests on human capability to create and invent new works. So legal protections then encourages the continual commitment of resources to further innovate. And the promotion and protection of these intellectual properties spurs additional economic growth. So the reason kind of behind it was there's money involved. And if people are spending, resources and money to invent things and to kind of progress and, then it makes sense to protect it. So there's an incentive to continue to do so, right? If you spend all this money to create a new product and someone can rip it off the next day and you make no money, then, you hinder innovation in the world. So the early days of intellectual property, if you think kind of back in the beginning, the before, Jerry Thomas per se, cocktail recipes were highly secret. People kept their recipes very close to the heart, and the art of bartending was something that was handed down on a very personal level. It was more of an apprenticeship, which is why when Jerry Thomas wrote his book, it was such a huge deal, right? It was the first time someone put to paper, hey, this is how you bartend. This is the recipes. and it's not a secret anymore. And then you kind of move on, kind of the other, we'll talk about it more, is you have the early tiki era, right, with Trader Vic's and Don's the Beachcomber, where there was it was very highly secretive. They even went to the extremes of not labeling the bottle, like, so they would put it in new bottles, right, and the bottles would be labeled like green triangle and blue circle, and you would mix ingredients without knowing what they were, right, like the famous Don's mix number 2. And even moving on to the revival, right, the sort of quote unquote modern era of this craft cocktail movement. Most bartenders had pocket notebooks with handwritten, recipes. That's when I started. That's how you learned. Was some old bartender would like you enough to share their little notebook with you, and you would take it home and write down as many as you possibly could. And you would have your own little pocket notebook, and you didn't share that with anybody. You would always see, like, back in the day, like Phil always like had his, but Brian had his little notebook, and it was always really cool to me. I was like, oh man, like if I could only get that notebook, I could be just as good as, these guys. And then there's been a shift, now there's a lot more online resources. There are compendiums, there are many, many books, many great books. And so you're kind of re-harking back to the early days, where information is a lot more available and a lot more shared. But with all this information being available, it kind of has opened up a lot of questions in our industry. This whole kind of discussion started with John DeBerry, who was part of our panel originally, asking a question and posting an article like, what does it mean to steal a recipe, right? Like, what do you owe somebody? So, if we talk about recipe theft, like what constitutes theft? Number one, like people are like, well, it's a copyright, like obviously if you breach copyright, it's theft. Recipes are not copyrightable. Their recipes have been said, they're a statement of fact, and directions to making recipes are procedural. So the U.S. government has deemed them not copyrightable. They're not under copyright protection. And so then that opens the question, like, well, then anyone could probably just take a list of ingredients, rename it, put it up on their Instagram, and monetize it, which is happening. You see it a lot. I think I think most of us know at Thug Cocktails and Die, and he does a good job of highlighting when it happens, right? And we've seen it happen a lot. And so it's how do you protect yourself, right? If there is money involved and someone's monetizing and it's your intellectual property, right? Someone, like, you've created a recipe, and someone else is going to take it and make money on it, shouldn't there be protections, right? And how could you protect yourself if and when this happens? I guess the other question is, more of a philosophical question, is what is a new drink? For the most part, many of us have discovered that when you create a recipe, half the time, like, you go through an old cocktail book and it's already been invented, right? Or for the most part, as cocktails are always like a riff on something. They're, the classics are there for a reason. And, to plug another colleague, Alex Day, his great book, Cocktail Codex is, there's really just, I think it was 6 cocktails, right? And everything is a variation of that cocktail. So are we really inventing something new? Some would say yes. I think it was Evan Freeman who really, like, was talking about it when it came to technique, right? When it's, is fat washing copyright or protectable, or is it a technique that isn't? And obviously it matters because there's a lot of kind of money involved. And I think one of the big areas where money really is important is when it comes to consulting, right? If you do a consulting program, and create a program for somebody. And this is, in the beginning, this is how a lot of bartenders were getting screwed, where, they were going to consulting agreements, they would give them their work product, and they thought they owned that product, but it turned out that they didn't, by, virtue of taking on the job. All of the intellectual property ownership rights, got transferred over to their employer. So I think, number one of the reasons why I went into law school was because I kept seeing my friends getting screwed. It's like, okay, cool. Like, how do we not get screwed? And just briefly touching on, one, make sure your contract is solid. And there are a couple different ways to do it. Make sure intellectual property rights are part of what you're negotiating. For the most part, when you work at an establishment, anything that is invented during work, so if you're a bartender employed by a bar, the bar and the establishment owns the rights to anything you create. That goes for cocktails, that goes for, if you work in IP, and if you work at Facebook and create a great code or a great app, right? It's the same thing. They own it. It's part of your employment agreement for the most part. When you're coming as a consultant, it always kind of becomes different. And there's been a lot of kind of legal back and forth of how do you best protect it. Currently, it's looking like the best way to do it is actually to use a license deal. Because we'll touch on copyrights in just a moment. But you can copyright books, you can copyright manuals. And so if you license that intellectual property, you can then pull that license. I think one of the prime examples of that right now is, you guys have seen Jerry. It's like a training platform offered by Proofing Company. You sign in, you log in, there's like online tests and, modules. But that login is contingent on the client paying the license fee, right? And once that fee is not paid, that content disappears, right? On a low scale, if you don't have the budget to do, massive, investment into a training platform that has online logins and stuff like that, one of the easier ways I've learned is to use, Evernote, right? Have all your, information in like an Evernote, and then share the notebook. And, if the client pulls, then you pull access to the notebook, right? Someone wants to sit there and copy paste everything, then there's not a lot you can do at that point. But, in terms of like getting the information plainly, that's one way to kind of protect yourself. So let's talk about copyrights. So, when you're talking about a copyright versus a trademark, copyright is an automatic right. You can file it, and you should file it if you want to, ask for protection from the government. But what's copyrightable? You have books, photos, videos. But again, a mere listing of ingredients or contents or a simple set of directions is uncopyrightable. So can you copyright a recipe? Technically, the recipe itself, no, right? So a copyright needs to have an expressive elaboration or a creative narrative on top of the mere listing of ingredients. And sometimes it's really easy to add that, right? Sometimes it's just suggestions on how to make a final presentation better. You can suggest pairings, or you can add a narrative to the story. And so usually if you look at the new kind of cocktail books, there's very few times when it's just a listing of ingredients, and it's more of this is how we thought of the process, this is how we're creating this drink, this is why we're using this particular ingredient. There's probably a narrative on the ingredient itself, whether the history or why they chose it, right? And that then becomes copyrightable. That copy becomes copyrightable. So if someone took that page, let's say out of like the PD cocktail book, and threw it up on their website, then that would be something that you could go after. And then you get into trademarks. Obviously, you can trademark recipes and you can trademark cocktails because Dark and Stormy has done it, right? Goslings has done it successfully with the Dark and Stormy. And and some others have well. But it is a very narrow and difficult part of the law. As I'm sure Angela can attest, there is a lot of work in having a trademark. Number one, you need a file form, right? So you need to file it with the USPTO. That's the U.S. Patent Trademark Office, and get it approved. So you have to prove that in commerce that you have a unique product that people want to copy, and there's reasons why you're gonna keep it protected. Then there's a filing fee. It's usually about $400, $500 per class. All right, so you're out a little bit of money, and you're out whatever you pay your attorney to file it, or you can do it yourself. And it has to be in commerce, right? So you have to be making money off of it, and you have to be able to prove that. And then you get your trademark, and you're super happy. But the second part is you need to constantly protect it. And so a lot of it is issuing cease and desist letters and going out into the marketplace and seeing if anyone is using your recipe and using your name. And so sometimes the upkeep of a trademark is more difficult than filing the trademark. So when it comes to recipe protection, there's probably an easier way, and that's when we get into the trade secret. Don Beach, going back to that tiki example, is a pretty good example of what you need to do to make it a trade secret if you really do want to keep your recipes proprietary, right? You hide the recipe, make it difficult for people to find, and that's enough. So that's a great example of trade secrets and making sure that you're protected, and that people were not supposed to know your recipes. And so, you would have the right to continue to make money on it. The Lynchburg lemonade is a famous example of when it failed. If you guys don't know, the Lynchburg lemonade is basically like a lemonade highball with Jack Daniels. So this guy, Tony Mason, in 1980 makes this like highball. It's like lemon, triple sec, whiskey, and I think lemon soda. So it's
Right.
it's like tripling down on the lemon. They get into it. It sells a bunch of Jack Daniels. Obviously, Brown Foreman comes to him, and he's like, "Hey, we really like your recipe. We want to use it." I think they had a loose agreement that the company would use Tony Mason and his band to help promote it if they decide to use a recipe. A couple months later, the Jack Daniels has reverse engineered the drink. They used I think they used sour mix instead of actual lemon, but it wasn't a hard recipe to figure out. So reverse engineer it, and then they start selling it and they promote it. And people, obviously, Tony Mason gets really mad. He sues them. In the initial suit, Tony Mason does win, but he wins $1. So it's a nominal win. And I think it was the judge literally just was like, "I'll give you $1 out of my pocket because there's nothing we can do. There's not a lot of protection here." So he then appeals. And on appeal, Jack Daniels actually ends up winning, and people are all up in arms. And at face value, it seems unfair. Like, this guy invented this drink. Giant corporation came over, took that drink. Now they're making a ton of money on it, and it's still, one of the drinks they used to promote the brand. However, as he was asking for trade secret protection, the evidence basically came out that this Tony Mason had no real legal standing to call it a trade secret, because he didn't actually protect the recipe, right? The amount of protection that he gave to the recipe was telling employees, "Hey, man, don't tell anybody." But it turned out that everybody and their mother actually knew that recipe, including their dishwasher, and a lot of the patrons, that came over. And so because he was so flippant in not protecting a secret, and it wasn't a secret, he basically lost any legal ground to calling it a trade secret, right? So if you're going to use a trade secret route, make sure you keep it a secret. Either I would say like the Coca-Cola formula is a great example, or the KFC's 11 secret herbs and spices, which may not have been leaked, but the amount of kind of protection that they had, and they got to keep that recipe secret, and they have legal rights to it by keeping a trade secret. So that would be one way to do it. Or you can get a trademark. I would say the kind of considerations into why you would trademark something is one, is it even worth it, right? Is it worth the expense? Obviously, a drink like the painkiller has been trademarked, and Goslings Rum owns that, and they deemed it worthy enough to keep it, to trademark it. They wanted it to represent their brand, and it was important to them to do so. But when you're talking about individual bartenders and individual cocktails, there aren't that many, I would say, drinks that make it into the quote unquote modern classics, that you see them kind of ubiquitously all over the world. I would say maybe like the penicillin is a great example. Maybe you could trademark the penicillin. Maybe it'd be good for Sam to do so, and then he could go after every single person who's out there making penicillins and get a buck out of them. But again, harping back onto intellectual property, he might not even own the penicillin. Milk and Honey probably does, and however that entity, because he was an employee of the bar when he created that drink. So again, these are things to think about on an individual level of, should I go for a trademark or not? Then touching on the Dark and Stormy, while we're all here right now, and we can talk about what it takes to keep a trademark, right? Number one, the journey to getting the trademark was not easy. Goslings fought very hard to get it, and it was the specifics that really kind of helped, right? It's Goslings Rum, Goslings Ginger Beer, that makes the Goslings Dark and Stormy. And so that was one of the factors that the patent or the trademark office looked at. Number two was actually doing the RTD, right? Having a packaged good in a pre-canned Dark and Stormy. The people in Washington, they're not they don't care about the craft cocktail movement. They understand trademarks. They understand a logo, right? Here's the Nike swoosh, right? Here's the Coca-Cola logo. Here's the word Coca-Cola. They understand that. They don't understand, here's a recipe of a drink. It has this thing called Goslings. I don't even know what Goslings, right? Like, that's them. So you give them a pre-packaged canned good, and you're like, here, this is a Dark and Stormy. It makes it a lot easier for them, right? They're like, okay, cool. This is a class 32 beverage. Aha, like, we got it. Specific run, specific ginger beer, done, right? So like, here's your trademark. After you get the trademark, like I said, you have to protect it. And so a lot of it is going after, sometimes it is going after small bars and being like, hey, like, we noticed you have a Dark and Stormy in the menu, doesn't have Goslings. That's the problem, right? Yeah. I think most famously, you guys took on Pernod Ricard, right? And they had a Dark and Stormy recipe on their website, but it used Malibu rum. And so that was a major suit, right? And coming from a small family, it takes a lot to take on the big guys, right? And I'm sure it took a lot of money and a lot of big kind of like legal expense team, right?
Yeah, and I think it's important to note too that the trademark, as you mentioned, is the name Dark and Stormy. So a lot of people assume Goslings was trying to protect the mixability of rum and ginger beer, when that's really not the case, because there are many rums that are absolutely delicious with ginger beer, but it really is the name Dark and Stormy that's important. So if you're visiting Bermuda, you enjoy Dark and Stormy, and you go home to LA to your local bar and you order Dark and Stormy, you want it to taste like it did in Bermuda. So it's really about protecting the integrity of the cocktail at the end of the day.
Yeah, exactly. That would be a great reason to go for a trademark protection.
Yeah.
Right, because it's like, maybe this rum and ginger tastes great, call it that, right? Or call it something else, right? Call it the fair and kind of nice or something, you know, there, and you do see that in cocktail names, right?
Yeah.
I think another one is like Audrey Saunders has the Jamaican Firefly, which is, to be honest, kind of a dark and stormy, but she's changed up some of the ingredients and she decided to call it something else, right? And so that would be in line with the trademark, right? And both are delicious drinks. And so yeah, so sometimes you send these cease and desist letters, and a lot of people get really kind of up in arms about getting cease and desisted. But
Yeah.
on the flip side, if you didn't do it, you would lose the trademark.
Well, that's it. It really is just protecting the mark, and it would never be our goal to to go as far as going to litigation with a bar. It's really our job to get out and educate people what the authentic dark and stormy is. And the majority of the time, when we enter those conversations with an account that would have had another rum listed with the dark and stormy, it's always very positive because, for the most part, they may have not known, right? It wasn't malicious. So that's really our role, is education in the most part.
Yeah. So I guess that's a perfect segue into when to get the law involved, right? When should you fight for it, right? Because you could easily, you do have an obligation legally to fight for your trademark, but you could easily win legally, but lose the PR battle, right? I would say, from personal experience, we had a bar called Painkiller in New York. I don't know if anyone here has been or has remembered.
I actually have been there.
Oh,
Yeah.
yes.
Yeah.
So yeah, we had a little tiki bar in the Lower East Side, and Pussers came after us, right, for the name. We didn't know that. In the beginning, we didn't know that Painkiller was trademarked, right? We just thought it was a cool name. It was a tiki bar. Pussers came after us, with a cease and desist, and it ended up backfiring in a pretty big way, right? And there was a big kind of uproar online, and with a lot of bartenders who then boycotted Pussers Rum, kind of in solidarity, which was probably not what they're intending at all. But it anytime you have a company coming after a little guy, it's never a great look, right? I think more. There's if you guys watch Kitchen Nightmares, there's a Cafe Hun episode where this cafe trademarked the term Hun, which is really important for the community, and she was going after people for using it, and the community came in uproars, and they boycotted her business, and she was on Kitchen Nightmares trying to save it, and then she ended up giving up the trademark, and I'm not really sure what happened to it. But these are examples of how you can not if Sam Ross went around suing everyone for making penicillins after he trademarks it, it probably won't be a good look for Sam Ross, right?
It'd be exhausting.
Also exhausting. So sometimes there's other ways to quote unquote win, right? Speaking on that, I'm sure Sam has had a greater career for allowing other people to make penicillins, and now he's globally known and the drink is globally known, whereas had early in his career been like, no, this is my signature drink, no one else can make it, or if you it's not a good look. It basically is what I'm saying. And I guess the question is, can you win, right? To your point, I do know that you guys usually go in and it's a bit of education, like, hey, did you guys know that this is with Goslings, maybe there's a partnership there, and you can always have a new customer or a new relationship versus a negative one, right?
That's a good example, because we do have partnerships with the Dark and Stormy where it has been licensed. An example would be the Tipsy Scoop, based in New York. They're a boozy ice cream company, so they're actually have entered in an agreement with Goslings and are able to call their ice cream Dark and Stormy ice cream. So the name is licensed to them and they're able to use it, but obviously they're using Goslings Black Seal Rum and producing that ice cream as well. So there are many opportunities for partnerships.
Totally. Yeah. The one of the examples that even made the ABA, like the ABA journal, the American Bar Association, which is, on the lawyer side, if you're making noise, I guess it's a pretty big deal. Was again going kind of harping back to Jack Daniels. An author named Patrick Wensink wrote a book, and then the cover looked like the label. And instead of kind of going after him in a mean way, this is actually kind of held up to a lot of lawyers as the example of a good cease and desist. Right? They reached out, and it was like, it was a very well written and a very kind letter. Right? It was like, hey, we understand you're a fan of the brand. Right? We love that you love us, and we love that you love our design, but unfortunately, if we don't protect our design, we're going to lose it. And if we lose it, then as a fan of brand, like, I don't think that's what you intended. Right? So basically what they did is they offered, hey, if you guys ever do a reprint, they didn't even ask they didn't ask that the cover be disbanded. They're like, hey, if you guys reprint it, we'll redesign it for you. We'll spend the money, and if you could, that'd be great. Right? And that ended up being a very positive moment for for them. I know, anecdotally, I think Red Bull does the same too, right? Like, there was a moment when Red Bull almost became genericized and became energy drink equals Red Bull, and once brand is generic, it also loses trademark. Right? Escalator is a perfect example. Escalator is no longer trademark because we call every escalator an escalator. I don't know what they were called before, but it is what it is. So they would go into clubs and be like, hey, can I get a vodka Red Bull? And if they saw somebody using another brand, they'd be like, actually, you're not allowed to do that. Two, like, we could sue you, or you could just use our product. We'll send you a bunch of promo material. We'll sponsor like a Red Bull night and throw you a bunch of money. Like, why don't we do that? And obviously it's like, do I get sued or do I get paid? Right? It's a very easy decision for most clubs.
That's a good example. And, the same thing goes when we find an establishment that has a cocktail list with
Mhm.
featuring the Dark and Stormy with another rum. We do offer to reprint the cocktail list, redesign it, and things like that. So it's really all an approach. You can never be heavy-handed, but you still have to be firm and protecting your mark.
Totally. Yeah. So on that note, I think we're at the end of what we were going to talk about. So I guess we're open for any questions, if people have them.
Okay.
Let's see.
Okay, so we've got one here. What are your thoughts on taking recipes from books and teaching people how to make them on Facebook Live, giving full credit to the bartenders and authors who created the drinks, of course?
Yeah. I mean, legally, again, there's, you're allowed to do so, right? It's usually it's fair use. You're allowed to use what's been published to create new content.
Yeah.
That's part of the protections in intellectual property, because you don't want to stop innovation, right? That was part of the policy decisions of that. But morally, right? That's a separate question, right? I think that's the sometimes legal and moral. For the most part, we try to make them the same, but they're not always the same. I think, yes, definitely giving credit as a base note, right? I think the industry does do a good job of kind of self-policing, right? So you don't want to be that guy, right? Definitely give credit where credit is due. And if you're getting paid on it, maybe throw them a little something, right? I think most of the people that I know would, probably turn it down. But maybe they would appreciate even the gesture, like, hey, like, I'm doing this thing. I'm going to be using your recipe. Like, I'm getting paid, X amount of money. Like, I'd, love to like share that with you, right? I think that's fair. But again, is there necessarily a legal duty to do so? Not really. But I do think there is a moral duty, and it's the right thing to do. Right, good karma is always good karma.
Yeah. Yeah. And another question here is, how long after infringement of a trademark or copyright do you have to protect it?
Ooh, I believe I want to say the statute of limitations. I'm gonna have to look it up real quick. So copyright infringement is 3 years as a statute of limitations. So um, once you find out, you have 3 years to basically go after it. Trademark, I'm guessing it'd be similar, but you don't lose trademark right away from not going after. You don't have to go after every single violation for a trademark. You just have to show that you are protecting it, right? Like it would be like a legal impossibility to know every single possible infringement. But you do have to go after them, right? So if you do let one slip or you don't notice it, but you've been diligent, then you can be like, no, like I've been diligently protecting it, but this guy in Podong town, no, like that doesn't have an online presence, happened to steal it, and I had no idea, and I had no reason to know, and that would help you in court. But you have to show that, yeah.
Yeah, and there's cases too where we've met resistance from certain establishments who just are unwilling to change, even though we've addressed it with them. But again, you have to pick your battles, and we don't want to be that guy either, right?
Right.
So, but for the most part, everyone's very forthcoming and willing to work with us once they understand the story and the history behind it.
Cool.
Next question here is, does a trade secret have the same protections as a trademark?
By and large, yes. So trade secrets, once they're violated, you can. So let's say someone broke into your vault, stole your secret recipe, and then went off and made a bunch of money on it. You would be able to recover the funds that they quote unquote misappropriated, right? Because they should not have had that recipe. They should not have had a secret. So they should not have made that money, right? You should have made that money. So in terms of that, yes, like you do have it, but it's a little bit less black and white, right? With a trademark, it's registered. Just a point that I forgot to mention is trademarks used to be the first in commerce, right? That was the rule. So whoever was the first to put it in commerce owned the trademark. And then if you forgot to file and someone else filed, as long as you were using it first, you were the true owner of the trademark. Now it's gone to a first to file as a default with if you can prove that you use it in commerce, then you will be allowed limited use of the trademark. For example, let's say, I don't know, I had an ice cream shop, right? And called it like Daniel's Ice Creams. And I had the shop open for, since 2020, and I never filed a trademark. And then in 2025, some other Daniel opens a Daniel ice cream shop, files a trademark, and then sues me for infringement. I could be like, no, actually, I was using it first. I get to use, the name. But he would still own the trademark, and I would have a limited use at this point. So originally, the trademark used to just hop to me and be like, okay, now I use it, you can't use it anymore. But as of a couple years ago, it's flipped. Basically, he will still own. Other Daniel will own the trademark. I will have a limited use of my own store, right? And maybe my little geographical region, but I don't own the trademark anymore. So it is kind of imperative and important to file now, as opposed to before. With a trade secret, obviously you're not filing it, right? So you do have to prove that this secret recipe or the secret formula or secret whatever is giving you, one, an economic advantage, and two, you taking the steps to protect it, right? And then three, this person, by stealing that secret, or has basically taken your economic benefit away, and that's how you get protected on a trade secret.
Okay. Cool. I don't see any more questions at the moment. I guess I should bring up an example when you mentioned the word cease and desist. There was a small brewery in New Brunswick, Canada, Picton's Brewing, and they had a beer, which one of their many expressions of beers, which they named Dark and Stormy. So obviously that was an issue for us, being a beverage as well and a beer. So we were able to come to an agreement with him, and he actually rebranded the beer Cease and Desist, and it's now his
Oh,
top selling brand. So, way to turn a negative into a positive there, and it's doing better than,
yeah.
now he's got a story behind it and everything like that. So it's now their flagship beer, Cease and Desist.
Yeah, that's awesome. Yeah, that's a great story. So yeah, there. I guess there are positives on being the other side too. I guess yeah, same for us. Like with Painkiller, we rebranded. We called it PKNY, right? And everyone knew what it stood for. But it probably made us way more famous as a bar than we ever really deserved to be. In a way. Sometimes getting sued is a good thing. I guess no PR is bad PR.
Yeah. Yeah, that's a good point. Oh, how long was PKNY open for?
We were in operation for a little over 3 years.
Okay.
I think we had, because we were taking over a lease, and then at the end of it, we were trying to renegotiate the lease, and it didn't happen. So
Yeah.
fortunately, we lost out. But yeah, it was a good time. Well, it was still going.
Great little bar. Yeah. Awesome. Okay. No more questions at the moment, I don't think.
We do have a couple coming in right
Oh.
now. So
Yeah.
we saw one. It just hasn't come into the doc yet, but there's a question: when did Goslings come out with a RTD, and what was the process of getting a trademark and getting it to market?
Okay. So the Goslings developed an RTD here in Bermuda in the mid 80s, and it went until 2010. And in 2011, we introduced the Dark and Stormy in a can in its current format, which is now, as I mentioned, canned in different locations and exported all over the world. Is it the only one trademarked in the market, and was the process the same? I don't think it's the only RTD that's trademarked. Obviously, there's many other brands out there that trademark their property there. Just a question here. So adding to a trademarked, oh, sorry.
There's just more questions coming in. Sorry about that.
Okay. Is it considered a trademark infringement if someone puts a Dark and Stormy or other trademark cocktail on the menu and adds other ingredients? So adding to a trademark cocktail recipe, but not subbing out ingredients in the original, like bitters? That's a good question.
That is a good question. I don't know if I don't know. Is my honest, I have an opinion where I would consider it probably, right? I would say probably, because depending on what you're adding to it, it could make a significant difference. I think, adding a couple dashes of Anglo bitters probably isn't making a giant difference, but maybe adding peach bitters does, right? Or, whatever homemade tincture. So I would say it really kind of depends. It would definitely depend on how much you're changing it, right? But I do think any change technically would be a something you could go after legally, right? Even if it was like a pinch of salt or whatever it is.
Yeah.
I do think. I mean, I don't want to speak for the brand, but I do feel like on your end, as long as there's Goslings in there, like you guys aren't gonna.
Well, I was just going to say that from our perspective, as long as they're using Goslings Black Seal Rum and the drink is tasty, that's the other thing is some people, their first experience with a Dark and Stormy may not be the genuine one, whether it's a house-made ginger beer that is on the spicier side or with another rum, and they say, I don't really like this cocktail, and that's what we're trying to avoid by protecting the trademark. I will use the example of lime in a Dark and Stormy. So there's always, do you add lime juice to a Dark and Stormy or not? And again, I think that's down to personal preference. So in Bermuda, they tend to like a cocktail that's a little bit on the sweeter side. So a wedge of lime would be served on a glass and squeezed into the drink if they want. But I remember some of my first experience traveling internationally to the UK, and bartenders were adding half an ounce of fresh lime juice into the cocktail. And it changes it a little bit, but in my opinion, brings the sweetness of the ginger beer in balance and creates something that's refreshing and resembling a dark and stormy. So, how much lime is too much lime is really personal preference.
Right. Yeah. And I guess to note, because this came up, is technically any amount of Goslings rum and any amount of Goslings ginger beer makes a dark and stormy, right? So you could have a ton of ginger beer, a little bit of rum, or all rum and a dash of ginger beer. You're still a dark and stormy under the trademark.
I think some bartenders, when they float the rum on top, they don't necessarily leave enough room for the rum, which can be a challenge as well. I mean, you always want the window on the top of your drink so it's not overflowing, but I think our proportion for a dark and stormy would be, 2 ounces of Goslings Black Seal rum, 4 to 6 ounces of ginger beer, depending on the preference. So I think that's a challenge too, and in some markets I've been in where they're very strict on the measuring. If you get 6 ounces of ginger beer and only 1 ounce of Goslings Black Seal rum, it tastes weak.
Yeah.
So important to get the ratio correct as well.
Totally. I saw something and then it disappeared. It was something about a rumor of a dark and stormy day.
What was that?
Oh, it came up and then it kind of disappeared. It was something about, I heard there was a rumor of a dark and stormy day, so I think they might
be. A rumor of a dark and stormy day. Yeah, so yesterday, June 9th, we recognized the 40th anniversary of the dark and stormy trademark, and it was our goal to do some virtual celebrations around that day. But we also wanted to give some time to separate from the current narrative, and so we decided to observe the dark and stormy day on June 23rd. So we're going to be featuring a lot of content online through our social media channels on Facebook, Instagram, and Twitter, where we're engaging the community globally that works with Goslings and features dark and stormy. So we're quite excited about the content we've been developing. I mentioned our partnership with Tipsy Scoop Ice Cream, and there's many culinary delights as well that we've been working on with the dark and stormy. So we're pretty excited to observe it there. But we've registered the day now. I mean, as you know, there's national days for everything, Oreo cookies to National Hydration Day, which is actually June 23rd as well. So we will be continuing to honor the legacy of the dark and stormy on June 9th in the future.
Awesome. Would the brand object to the use of another brand's ginger beer?
Not at all. And Goslings first introduced Stormy ginger beer in 2009. There were a number of other brands of ginger beer available in Bermuda, in the 1920s up until now. And the reason Goslings developed their own ginger beer was to promote the dark and stormy in markets where it was difficult to get good quality ginger beer, namely the United States. As I mentioned earlier, British ginger beer is a British tradition, therefore very easy to get in the UK. And however, in America, as we began expanding into new states and into Canada and other markets like that, the access to quality ginger beer was challenging. So it was very difficult to promote our signature cocktail. So the decision was made in 2009 and to introduce our own ginger beer. And Malcolm Gosling, who's the CEO of Goslings International and 7th generation of the family, partnered with a company called Polar Beverages, who's based in Worcester, Massachusetts, and it's owned by the Crowley family. So again, another family-owned business, and they are the largest soft drinks or privately owned soft drink company in America. So it was a really outstanding partnership introducing the ginger beer there. And we've been very fortunate to gain a lot of distribution. And I wish I could credit it all to the popularity of the dark and stormy. However, there's another cocktail that includes ginger beer, which is also very popular, that has helped to build the distribution, which is the Moscow Mule. So let's face it, if our ginger beer makes vodka palatable, it's really a testament to the quality of Goslings ginger beer. But we found a lot of vodka brands suggesting Goslings ginger beer as their ginger beer of choice to make the Moscow Mule with, which was great. So it helped drive the distribution. And in the West Coast of the US, where you are, Daniel, in LA, for example, a lot of people have no idea where Bermuda is, and they don't know the Goslings brand as a rum brand. They actually know it as a ginger beer brand. So the ginger beer has developed a whole new set of opportunities for us to grow distribution on Goslings Black Seal rum as well. But in terms of, back to the question there about do we, mind whatever ginger beer you use? I mean, no, ours was developed to produce what we think is a really well-balanced dark and stormy. However, there are a number of outstanding ginger beers in the market, and a lot of craft bars take the time to make their own house-made ginger beer as well. And some of those are absolutely delicious, and some might be a little spicy for certain palates. But no, we encourage that, definitely.
Awesome. Yeah. Cool. Don't see anything else, so yeah. Don't know how to close out.
All right. Awesome. Well, thank you, Daniel, for joining us. It's good to see your face again.
Yeah.
Been,
Hopefully we'll
almost
see
a
each other
year,
in
I
person.
suppose, right?
Totally.
Yeah.
So yeah, thank you guys for listening in and joining our little chat, and thank you, Andrew, for having me here to talk a little bit about the legal aspects of cocktailing, which is always fun. And yeah. And if anyone has any questions, obviously I'm on Facebook. Instagram is probably the best way to get me. At Make 'em Say Un, MakeemSayeun. And I'm always open for questions, and I'll answer any DM really. So yeah.
It's great. We appreciate that. And same thing for Goslings. You can reach us at Goslings Rum on Instagram, or send us a message on Facebook, and myself or one of the team will get back to you really quick. But we're looking forward to celebrating on June 23rd with a variety of digital content from around the world. And we'll be here in Bermuda with Malcolm Gosling and his son, Malcolm Gosling Jr., celebrating the day. So we look forward to that. Thank you.
All right. Cool. Thank you, guys.
All right. Cheers.